So good morning, everyone, and thank you for joining us for another EIA Lunch and Learn. So today we have, again, our special guest, Kate, and she did such an amazing job for part one of our Lunch and Learn about 2 weeks ago. And so we're going to be continuing on to part two today. So again, if you have any questions, um, feel free to type that into a chat or hold it to the end, whichever preference you have. But again, thank you for joining us. And again, we're here for some more valuable information. So without further ado, I'm going to present to you Kate.
Hey everyone. So this will be part two of the presentation on human rights in the workplace in Alberta. And just to remind everybody, this is not legal advice. I cannot give anybody legal advice. I can only give information. And in terms of questions, I said this last time, but I'll just remind people, if you have a question while I'm talking, I don't mind being interrupted. That's totally fine. Please interrupt me if you want to put it in the chat, or if you want to just interrupt me verbally, that's fine too. I want to make sure that everybody understands what I'm saying, so I welcome questions. I cannot give answers though on specific circumstances relating to your workplace. I don't mind considering like hypotheticals, but in terms of specific situations, I can't give advice on that. So I just wanted to remind everybody of that. And I will provide a brief overview of what we talked about last time as a refresher. So we talked about what the Alberta Human Rights Act is and what its purpose is, who's protected under the Act. And in that regard, we also talked about what is a physical or mental disability under the Act, which the Act does define. We talked about what discrimination is under the Act. So we talked about the legal test for discrimination, which when a complaint is made under the Act, the initial onus lies with the employee. So they must prove three things: that they have a characteristic protected by the Act, so a disability, that they experience some sort of adverse impact or negative effect in the workplace, and then finally that the adverse impact is connected to their disability or their protected characteristic. And so once they satisfy that, then the onus shifts to the employer to justify the discrimination. And we also talked about how the Act protects employees from really the very beginning of the employment relationship and even before the employment relationship. So in the context of the job applications and advertising, the Human Rights Act protects people from discrimination in that process. It protects people during the employment, and then also termination. It protects people from being terminated for reasons connected to disability. So that's what we talked about. We talked about some other more detailed stuff too, which should be in the recording. So Elaine, you can watch the recording and learn about that more specific stuff. So I will share my screen now. We're going to move on to talk about what happens next if discrimination is proved. Bear with me here. Okay, can everybody see? Well, if somebody can't see my screen, it says, what happens if an employee proves discrimination? Can you just raise your hand if you can't see the screen? Okay, you can't see the screen. All right. I'm not sure how to fix that. I'm not very technically savvy. Let me see here.
Hmm. Daniela says that he was able to see your screen, and so was I as well too.
Yeah.
Uh,
Well, I'm going to be, if it'll show up on the recording, maybe I could just go ahead. I'm going to be talking about what's in the substance of the slides anyway. So if
okay.
that's okay, because otherwise I'm not really sure how to fix it. Okay, so I'm going to keep going here. All right, so what happens if an employee proves discrimination? So that three-part test that we talked about. So when that happens in the context of a complaint, so for, like when there's an actual hearing and tribunal members deciding whether there's liability under the act. So we have the once the employee proves the three-part test, then the onus moves to the employer to justify the discrimination. Section 11 of the Human Rights Act provides this authority. So it says that where there's a reasonable and justifiable contravention of the act, then there is no contravention of the act. There's no discrimination that gives rise to liability. And the reason why I kind of word it that way is because in my mind, there can be discrimination even if it's justified. So just because a discrimination is justified doesn't mean the discrimination didn't happen. It just means that the circumstances of such are that it was justifiable discrimination. And so in the context of employment matters, there's a specific test that an employer must satisfy to justify discrimination. And I'm talking about discrimination doesn't relate to anything like harassing somebody because they have a disability, that sort of thing. I'm talking about like conditions of the workplace that negatively impact a person with a disability. That's what I'm talking about here when I talk about this, what's called the bona fide occupational requirement test. That's the name for the legal test that must be satisfied by the employer. And so bona fide means real or genuine or sincere. So when we think about the definition then in the context of this name for the test, the bona fide occupational requirement, it really means there has to be a real or genuine or sincere occupational requirement that justifies the discrimination. So we have a legal test and it's a three-part test. I think it's funny just from a legal perspective that these tests that we have always seem to come in three parts. So first, the discrimination test, three parts, bona fide occupational requirement, also three parts. So what are the three parts? So these three parts are set out in numerous cases. I just plucked one from the various cases I have access to. So this is a case from our Court of Appeal of Alberta, which is the highest court in Alberta. And they set out the test, and we can see here on this slide. So the court says, as I told everybody a minute ago, the employer bears the onus of demonstrating accommodation to the point of undue hardship, which is a consideration under this bona fide occupational requirement test. And so the Court of Appeal tells us that the test is, number one, that the employer adopted the standard for a purpose rationally connected to the performance of the job. Don't worry, I'm going to translate this all for you. So that's the first one. The second factor is that the employer adopted that standard for in an honest and good faith belief it was necessary to fulfill the work-related purpose. And then lastly, and this is the most significant part of the test, the most onerous part of the test that must be satisfied by the employer, which is that the standard is necessary to complete the work-related purpose. And to satisfy that, the employer has to show that it was impossible to accommodate the employee without incurring undue hardship. And I'll talk about what undue hardship is, when undue hardship can be satisfied and all that. So you have a clear picture of what to think about if you're faced with needing to accommodate an employee. So what are the lengths that you must go to do so? Okay, so the first step, the first part of the tests, which is the standard was adopted for a purpose rationally connected to the performance of the job, which is a mouthful. So if the condition of the employment that's discriminatory can be justified because it has a connection to the duties of the job, then this will be satisfied. This first stage of the test will be satisfied. So I have some examples here. So these are pretty basic examples. Sometimes the circumstances can be a bit trickier and you need to do a more in-depth consideration of the circumstances of whatever employee you're dealing with. But these are basic just to give you an idea. So a truck driver job. A truck driver has to be able to have a certain level of vision. If they're legally blind and can't drive, well, that's a problem, obviously, right? So being able to see adequately is rationally connected to the performance of driving a truck. There's a rational connection. A letter carrier. Now, I'm actually not sure if they have to be able to walk to carry letters, but just for the purpose of this example, letter carrier must be able to walk for a certain amount of time per shift. So being able to walk is rationally connected to the performance of delivering mail. So when you're faced with a situation with an employee, the first thing you need to ask yourself is, okay, is the condition that we're imposing on this person rationally connected to the duties and responsibilities that they must fulfill? And if the answer is yes, then you move on to the next stage. Okay, second stage, good faith. So the employer also has to prove that the standard that's at issue here was adopted in good faith and for an honest reason. Okay, so this is usually fairly easily satisfied for two reasons. Number one, I think it's pretty rare that an employer is maliciously imposing a standard on a person with a disability. So that's the first reason. And secondly, I think it's also pretty hard to prove in evidence that it's a fact that an employer is taking this sort of action for a malicious reason. So usually this is easily satisfied. If there's some evidence that proves it's a fact that the reason the employer did what they did was because, for example, they have some sort of personal animus towards people with disabilities, well, then that would probably be bad faith. And so not going to be justified. Okay, third stage. So this is the most onerous stage. I think this is the stage that most of you probably have questions about or don't really know a lot about. So I'm going to take some time to go over this third stage, the third part of the test, which is that the employer must prove that the standard is reasonably necessary to the accomplishment of the legitimate work-related purpose. So the employer has to show really that it's impossible to reasonably accommodate the disabled employee without imposing undue hardship upon the employer. And I use the word reasonable because the law on this point is that accommodation doesn't have to be perfect. It doesn't have to be the preferred accommodation of the employee. It only has to be reasonable. So for example, if there are two legitimate options, right, in terms of accommodation, or a variety of different options, and the employee, and all are reasonable and all would accommodate the person. If the employee prefers one option over all the other ones, well, the employer could still choose another option. Like, let's say maybe another option would impose less financial hardship on the employer and would be just as good as the one option that the employee preferred. That probably, I say probably because I cannot say, you know, for certain in every situation this would be the case, but that probably would be reasonable accommodation, even though the employee preferred something else. So I want to raise that for everybody as well. Okay, so just going back to this first paragraph here. So really, this means that the employer needs to consider, okay, is this standard that I'm imposing really at the end of the day required to complete the job? And if it is, are there no accommodations that can be implemented without causing undue hardship? So before I get to undue hardship, I just want to make sure everybody explains what accommodation means and what it can look like. What are some examples? So accommodation is really adjusting the workplace to make it so that the person with the disability can do their job, taking into account their specific needs, right? So some examples might be maybe they need some extra time off to attend doctor's appointment or get treatment or stuff like that. Maybe they need more breaks than a person without the same disability. Maybe they need less shifts. Maybe they need their work duties or responsibilities sort of reduced or altered in a way. Maybe the work environment needs to be changed. So maybe there needs to be mobility aids, hearing aids, you know, equipment to help them do their job, things like that. And so that's what accommodation can look like. Now, accommodation examples are not set in stone. It depends again on the disability and what ideally the medical professional is saying that the person needs in terms of accommodation. So of course, it's ideal to have that medical component as well to help guide what you do. Now, usually, or at least up until recently, it was pretty clear that there was no requirement in the accommodation process for an employer to create a new position. So for example, if an employee couldn't do the job at all because of the disability, the law was that the employer was not obliged to just create a whole new position for them. But there was a recent case that found that an employer's failure to even consider rebundling different tasks to create a position for the employee resulted in a failure to reasonably accommodate. So this is sort of a shift in the law telling us that, okay, well now the tribunal's telling us no, employers do have to consider can we create some other position for this person? Can we bundle a bunch of different tasks together to create a position for the person? So that's something that I would say employers should consider when they're doing the accommodation analysis. Okay, what's the quality of investigation into accommodations required? Superficial type investigations are not likely to be accepted by the tribunal as satisfying that third part of the test. We have some guidance from the court about what sorts of things should be considered by the employer when they're determining if they satisfied their legal obligation to investigate accommodations. So some things to consider. Did you investigate alternative approaches? And if you did, and there were appropriate accommodations identified, why were they not, or why can they not be implemented? Is it required for all employees to meet the standard, or could some employees who do not meet the standard be accommodated? Is there a way to do the job that's less discriminatory while still accomplishing that legitimate work-related purpose that we talked about under the first factor? Is the standard required overly burdensome? So could it be relaxed? Have all parties who are part of the investigation process fulfilled their roles? So usually, especially in bigger companies, I would expect there's numerous people that are involved in the investigation process. So management, HR, maybe, you know, there's disability people. Have all those people completed their roles in the investigation, or has somebody left something, what's the word I'm looking for? Not fulfilled. So that's something to consider as well. So those are some things to consider. And if you're faced with a complaint, you will be required to show your work. You will need to prove that you went through a meaningful investigation and analysis of whether accommodations could be implemented, and if the answer is no, why that is. And so it's ideal to have some sort of policy, I think, and procedure in place in your workplace about what are the steps to be followed when there's an employee that needs accommodation. I think that would be very good for many reasons. And of course, that you follow that policy and procedure too. Because just having a policy and procedure in place in and of itself is not going to be enough. You're going to need to also show that it was followed, you know, in a meaningful way. So that's very important. Okay. And that's very important too when we consider undue hardship and showing undue hardship, because just saying to the tribunal, well, it would have been too hard, you know, to implement because we would have had to spend money or something like that. That's not going to be enough. You're going to have to prove undue hardship. So what is undue hardship? This arises if accommodation would create significantly onerous conditions for an employer. Some examples can be financial costs or serious disruption to the business, but you still have to be making sure you're making every effort to accommodate. And some hardship may be necessary to accommodate. It's only if the hardship's undue that the employer is going to be able to successfully defend a discrimination complaint. So what's undue hardship? Okay, again, it depends on the circumstances, but here's some things that might give rise to undue hardship. Financial hardship. With this one, you're going to have to show intolerable financial hardship, and you have to prove that as well. You're going to have to prove that you crunched the numbers and it just would have been too hard to, your business would have taken a too significant blow. Next, chronic absenteeism might be undue hardship. If accommodation substantially interferes with the rights of other employees, that might be undue hardship. It might be impossible to implement the accommodation, or it might be a safety risk to others. So those are the sorts of things that might be undue hardship, but again, it depends. The main question really is you couldn't have done anything else reasonable or practical to the point of undue hardship to avoid the negative impact on the employer. I really, really recommend that you get legal advice if you're at this point where you're thinking, I think we've done everything that we could and we can't do anything more without undue hardship. I recommend you get legal advice before you make the final call on whether you tell the person, there's nothing we can do, or, here's what we can provide. We can't provide anything further to you, that sort of thing. That I recommend that, because a lawyer might be able to give you some more information on, okay, maybe you should try XYZ, or have you thought of this? And that's, for two reasons. It's to make sure the employees getting accommodated, and also to make sure that the employer can be assured that they've done everything that they can to satisfy that third part of the test. Okay. So I thought it might be useful to go back to the sections of the act we talked about last time and just kind of think about the bona fide occupational requirement test. So section 8 relates to advertisements and related stuff. So there's no prohibition, there's no absolute prohibition from citing a preference for a person without a particular disability. You can do that, but you have to make sure it's justified under the bona fide occupational requirement test. And the truck driver examples is relevant to that. Section 7, conditions of employment. So similarly to Section 8, you're not prohibited from having work conditions that might negatively impact a person with a disability, but again, you have to satisfy that test. So for example, maybe it would be financially prohibitive for a small business to install a particular mobility aid. That would be discriminatory, but it could be justified. And also say that if you're a small business, I think that financial constraints are more closely considered, as opposed to if you're a huge company with a lot of funds. And then termination. So again, not prohibited from terminating somebody for a reason connected to the disability, but again, only if you've satisfied that test. So I just wanted to emphasize, like, you can do these things, but you just have to make sure that it's for a bona fide occupational requirement reason. So that's why I wanted to emphasize here. Okay, so what are the consequences of discrimination? So let's say you can't justify the discrimination. So the tribunal has a wide-ranging authority to award a lot of different things. Really, yeah, so a wide variety of things. So first is general damages to compensate for the discrimination itself. And lately, we've been seeing a rise in awards. So whereas a few years ago, it was really, between 5 to 20,000, we're seeing now awards that are between like 30 to 50,000, and I expect they're only going to get higher. So be aware of that. Next, lost wages. So for example, somebody couldn't work because they weren't being accommodated, then the tribunal can award lost wages for that period of time. Also, if somebody's terminated for reasons connected to their disability, the tribunal has the authority to award lost wages as a result of the job loss. And that analysis is not the same analysis that's used in non-discriminatory terminations. So you might be aware that in without cause terminations, there's a specific test that's applied if discrimination is not a factor. And usually there's like a cap on, well, I'm not going to get into that, but there's a different analysis that applies to that. That's not the same analysis that the tribunal can use. And so that means that an employee might be awarded much more if the termination is connected to discrimination, as opposed to if the termination was just without cause for reasons not connected to disability. So employers should be aware of that. And that's what I meant by income loss. And other expenses. So let's say, for example, the employee needs to get counseling because they're distressed over the discrimination. The tribunal can award compensation for that. They can order the employer cease the discrimination and cease similar discrimination in the future. And then lastly, they have a general authority to do anything else that they think is proper that would put the person back in the position they would have been in if they were not discriminated against. So since we have limited time left, I have some examples of human rights cases. Well, let's see if I want to get, I will see if we have enough time. I'm going to skip these examples. There's just some cases to kind of give people a practical understanding. But I'm going to skip that because I think it's more important to talk about the procedure of making a complaint. And if we have time, I can go back. So next thing I wanted to raise is retaliation. So the Act protects employees from being retaliated against if they make a complaint. It also protects witnesses who cooperate in somebody making a complaint, and generally anybody who assists in the complaint process. And so the Act prohibits retaliation, which means, so just as an example, let's say an employee makes a human rights complaint and the employer cuts their shifts in response or fires them in response, so or harasses them in response to the fact that they made a complaint. They can be liable for general damages relating to that. And the underlying complaint doesn't even need to be successful for somebody to be successful on a retaliation complaint. So for example, if somebody makes a discrimination complaint and the employer retaliates against them, the employee's discrimination complaint fails. That doesn't mean they still can pursue the retaliation complaint. So be aware of that. Okay, procedure under the Act. So number one, there's a 1-year time limit to complain. And so this 1-year time limit is measured from the date of the discrimination. It can also be measured from the date of the last instance of the discrimination. So if there's a bunch of like, if it's sort of like a continuing course of discrimination over a period of time, then if in those cases, it has to be made from the date of the last instance. If the 1-year time limit is missed, that's it. There's no discretion to extend the time limit. It is absolute. So be aware of that. Now, the process for making a complaint. So the Human Rights Commission is the body that deals with investigating complaints. I think I explained that last time. So we have the commission, and so they do the intake. They receive complaints. They decide if they accept the complaint. So if it meets the standards of complaint set out in the Act, then they'll accept it. Then they'll ask for a response from the employer. And then one of two things can happen. There can be a conciliation, which is like, it's like a mediation. It's a without prejudice discussion between the parties with a mediator, with the purpose being to try to settle the complaint before it going even further. or there can be a director review. Now, director review is when the director of the commission reviews the complaint and determines if there's a reasonable basis for it to be successful. And if the answer to that is yes, then it goes into the hands of the tribunal. If the answer is no, then that's the end of it, subject to any appeals. So there are various appeals that a complainant can do if the director denies the complaint to the next stage. But let's say your complaint's accepted and it goes to it passes the director review, then it goes to the tribunal. So the tribunal is the body that hears the trials of these complaints. In that process, there's usually another attempt to try to resolve the complaint. If that's unsuccessful, then there's like a pretrial process, which I won't go into here. Then ultimately there's a hearing where a tribunal member will decide if there's unjustified discrimination. And regardless of the result, if there is or isn't, whatever the tribunal member decides, either the employee or employer then has a right to appeal that to the Court of King's Bench through something called judicial review. And then you could theoretically go to the Court of Appeal and then theoretically go to the Supreme Court of Canada. So like I won't get into all that, but there's ways you can appeal the final decision from the tribunal. And this whole process takes many years. I mean, even to get to the tribunal, to get past this initial commission stage to the tribunal, probably takes between 3 to 5 years. And then to actually get to a hearing, another 1 to 3 years. So very lengthy process. Okay, so I was asked to just
Kate, I just had a
yes,
quick question.
yeah.
So I guess during that process, um, if someone does make that complaint, are they being and I'm assuming that they wouldn't be obviously working during this time frame, would they be compensated while this complaint is going through that process of each step, or
Well,
uh, no, go ahead.
yeah, you can still be employed and make a complaint. That's why we have the retaliation section, right? Because it prohibits employers from retaliating against somebody if they made a complaint. I mean, it'll probably be awkward in the workplace, but you can make a complaint if you're still working there. But let's say you're not working there. There's no way to get compensation from the employer in the meantime, unless they agree to settle it for a certain amount. So by settlement, that just means you agree between the employee and the employer agrees that in exchange for a certain amount, the employee will withdraw their complaint.
Perfect. Okay.
You could
And I
get
think
you could probably get EI though if they qualify, if they're not employed.
okay, that makes sense. I believe Aleem has a question as well. Go ahead, Aleem.
Yes, my question is, I'm assuming this would take a lot of money. So, for people that we support, like in job development, for example, sometimes these individuals don't have the money to kind of do the day-to-day their living stuff, and that's why they need jobs. And if something happens on the job like this, and they need to do something and move ahead, uh, what options do they have if financially they are not able to do all this and go through the process?
Well, it is unfortunate that this is a legal process that's complicated, and it's best to have a lawyer, right, to help you, and lawyers cost money. That's a
Yeah,
reality.
legal aid or something like that?
Pardon
Where
me?
can legal aid help with this?
Legal aid doesn't cover this stuff. Legal aid covers criminal and family.
Sure.
Now, there is some people might have heard of the Edmonton Community Legal Center.
Okay.
who provide free advice on employment type matters like this for low income people. You have to qualify though. I don't know what their qualifications are. And I understand that they, from time to time, also take on cases. Now, please don't go to them and say, Kate Engel said that you would, take this on, because I can't say for sure. You'd have to talk to them. Now, I also am aware of, I believe it's called the John Humphrey Center for Human Rights. I don't know if they assist in this type of thing, but I would try contacting them too to see if they could at least help with drafting the complaint. I know they've helped drafting complaints in other contexts before. That might be an option. Now,
I guess that all I kind of wanted to know is that if there is options. So if we run into clients that are
Mhm.
expressing this kind of issue, then is there some resource that we can give to them and go here, or
right.
you want to go there, and then go from there? Because legally we can't do anything in terms of that process.
Mhm.
But at least we can give them some resources to say, if money's an issue, here's some of the places you can go.
Right. Yes. I'll also say this. So those are a couple of resources, right? Also say this. So I think that it's very important to make sure that the complaint itself is drafted appropriately. So that initial document, that it sets out the grounds for the complaint, the factual basis for the complaint. That's very important. If it doesn't have to be a lawyer, if somebody can help somebody who maybe doesn't have the capacity to do that, if somebody can help them draft out that complaint and submit it and at least get the process started, I think that would be good. And also, the commission itself has a duty to accommodate. So if somebody needs some sort of accommodation, which doesn't include a lawyer, right? They don't get their own lawyer. So they could ask for help with accommodation there. Somebody, also I would expect would have the ability to have a support person to help communicate for them. Doesn't have to be a lawyer. And also, if the complaint gets past the director review stage, then if somebody doesn't have a lawyer, the commission has the option to prosecute the complaint. Now, that doesn't mean that the commission's lawyer is the complainant's lawyer, but more often than not, their positions are aligned. So the complainant's lawyer or the commission's lawyer looks out for the public interest, which usually is that they will be arguing that there is discrimination. So now that doesn't happen all the time, but sometimes that happens. So the person might have the indirect assistance of a lawyer. But I think if they can get through that initial stage with some sort of assistance, like I think that's possible. It might be a bit more difficult without a lawyer.
All right. So I guess the first point of contact, if needed, is to say to go to a commission, and then the commission would direct them accordingly.
Yeah, if somebody needs help making a complaint, like, sorry, are you?
Yeah, that's what I mean. So if we're counseling a client and something, if we need to resource them as a job developer or a career practitioner, do we just resource them to the commission and then kind of let them kind of go with the process?
I would first see if one of those pro bono places that I talked about could help them.
Okay. If you
Um,
can send that name out later in your slides, that'd be awesome.
yeah,
Thank
sure.
you.
Of
Thank you.
course. Yeah. But if worst case scenario, they can't and they need some sort of assistance, then I would reach out to the commission and explain, I have a
Sure.
complaint, but I can't communicate, very well. I don't know what assistance they will provide. I've honestly never had that circumstance arise for myself, but I would
Sure.
reach out, and I would reach out far in advance of the 1 year, because the 1 year is It cannot be moved. It cannot be changed.
Right. Okay, thank you very much.
You're welcome.
We also have Samara. Forgive me if I pronounced that wrong. She also has a question.
Okay.
Go ahead, Samara.
So the question is that who do you go to if the employer is get caught with a fraudulent contract? In other words, they basically come up with a contract. They use someone's name to, and then what do you do? Like, who do you go to if you caught that?
I didn't quite understand this. What do you mean? A contract? I'm not sure.
Well, someone who's get injury from work, and then what they do is they use a fraudulent contract to calculate a long-term disability. You know what I'm saying? It's like so if you work whatever hours you work, whatever, you have a contract there, but then somehow they change the content. They basically come up with somewhere like, with a signature with a contract. This is what you're making, this is what it is. And then they give that to the long-term disability to calculate the long-term disability. But then the whole letter is fudge. It's
Well,
what
if
do you do?
somebody
Like,
is
what do you
forging a contract, then we're in criminal law land. And you should probably be reporting that to the police because that's a
what
crime.
happened if the police?
Pardon
It
me?
is a crime, but it is a crime, but then the police won't investigate.
Okay, well, I would go to a lawyer because that's pretty complicated situation. But I will say that if hypothetically an employer to try to get out of paying disability fraudulently creates a fake contract, then that is discrimination on the basis of disability. Because if assuming the person has a disability, that's number one factor that's met. Number two, adverse impact. You're not getting paid disability because of a fraudulent contract. Okay, that's met too. And then number three, the fact that you're not getting the disability benefit is clearly connected to your disability. So that would be satisfying the three-part test of the discrimination test. And if you can't resolve it with your employer, then you can make a complaint. You can make a human rights complaint, but you got to do it in the 1 year. In this hypothetical situation.
Okay, thank you.
Yeah. Okay, so I was going to go and talk about the Employment Standards Code, just spend 30 seconds on it. I don't mind staying longer if people have questions about anything I've talked about though after. So why don't I just quickly talk about the Employment Standards Code? And I'm not going to share my screen because that issue happened again. So I'm not going to do that. So the Employment Standards Code, just be aware that the code permits an employee to 90 days of unpaid leave if they're suffering from a long-term illness or injury. The conditions are set out in section 53.97 of the code. So the employee must have been employed by the same employer for 90 days. That's number one. And there also must be a medical certificate. So the code actually does require medical information to justify the unpaid leave. And an employer is prohibited from terminating an employee during this type of leave. So in a nutshell, the code permits a max of 90 days of unpaid leave due to long-term illness or injury leave if certain preconditions are met. Now, this is separate from the Alberta Human Rights Act. It's totally different. So keep that in mind. In terms of accommodation, that's assessed under the Human Rights Act. And so it may be that a person would be entitled to more leave than 90 days under the Human Rights Act if that was reasonable, like a reasonable request or reasonable accommodation. So yes, I just wanted to clarify they're different. they consider different factors, but the code does permit 90 days unpaid leave for long-term illness or injury if certain factors are met. So I just wanted to briefly comment on that because I was asked to comment on the code. Okay. So I don't have anything else to say. We don't have time to go over those case law examples, which is okay. That was just kind of like a little bit of an extra thing I'd added. So does anybody have any questions about anything I've talked about, either from the first part or the second part?
Hi, I'm Mallory, and I'm sorry I was late.
Oh, that's okay.
I understand like privacy laws and things, but sometimes I'm lucky enough to request like a recording when I'm late or when I can't make it to a class. Are you able to do that by any chance?
Well, I understand that both presentations are going to be recorded and people can access them upon request.
Oh, I don't know. I don't
Yeah.
know. I didn't know if it was like a if you could send me. It's just that I'm very interested in the class, and I just joined, so I've missed some.
Yeah, Keemish, I think or somebody
Mallory,
from Good. Yeah.
yeah, Mallory, if you can put your email in the chat,
Yes,
then we
ma'am.
can connect with you after once the recording is done, and we can send it out.
Thank you so much. I just wanted to give you that respect by asking first. And thank you guys for what you do. Yes, I just put my email, so hope it was a good class, and I'll follow you on the app and for your future classes.
Okay, sounds good.
Yes, ma'am. Thank you.
You're welcome.
So we also have Aline with a question, as well as Chantel as well. So Aline, we'll let you go ahead, and then Chantel, you can ask your question right after.
Thank you. Quick question is that in order for the employer to assist the person that's having the accommodation request, I just wanted a confirmation. Does the employer need to disclose disability and requirement of accommodation, or because what we usually advise is that if you want to be protected by these laws, the employer needs to know that accommodations are needed. So you can't just go later on and say, oh, well, I need an accommodation and you didn't do it, when the employer doesn't even know that you need it. So is that still the case?
Yes, and when you review the first recording, I talk about in great detail
Perfect.
what that's all about.
So please do send me the first recording, whoever is doing the sending. I'd appreciate it. Thank you very much, and thank you for your time.
Yes, you're welcome.
Go ahead, Chantel.
Hi there. Sorry, my camera is being a little bit funny today, so I'll just go on the microphone. I was going to ask, when you mentioned the necessary accommodations made, there's an onus on an employer to kind of explain that they potentially like cannot make necessary accommodations, but they don't necessarily have to be to the preference of the individual who's asking for them. In a situation, and I guess maybe this is a bit nuanced or case by case, but in a situation where the person has made the employee has made an ask for accommodations and has expressed that they can't complete certain elements of their tasks or job if they don't have accommodations, and an accommodation is provided to them, but it's not sufficient to provide for their needs. Would you say that there's still avenue for there's still an avenue for them to follow up or maybe pursue some kind of like legal action if they feel like, you know, in an extreme example, they have mobility issues and they're like, okay, well, we'll give you the accommodation of letting you be 5 minutes late to work, but you still have to, you know, commit to or accomplish work that's outside of your mobility like access, what you can do in a day. Would you say that that's still a avenue? They still have an avenue to pursue that?
I would say if the employee clearly advised them that, okay, partially I've been accommodated, but I'm still having difficulties completing my job, so I need help with further accommodations, and the response is too bad, so sad, or words to that effect, then yes. But if the response is, okay, well, we'll do further investigation about how we can support you, and then they do that, and that results in reasonable accommodation, then probably no. But I think it's best practice in all circumstances to give the employer a chance, right? Before taking, unless you're coming up against that like 1 year, then I might say, just pull the trigger on a complaint now, so that your right to complain is protected, and then we can deal with all the further requests later, right? And you can always to withdraw a complaint, so you with no consequence to you. So if you make a complaint and then you don't want to proceed with it anymore, or it's resolved, the issue's resolved like immediately after you make the complaint, you can always just withdraw it, and there's no consequences for that.
Okay, thank you. That's a good answer. Thank you.
Don't see any more questions, so if there are no more questions, thanks for coming. I really enjoyed presenting on this topic, so yeah, thank you for coming.
Absolutely. Thank you so much. Thank you so much, Kate, and thank you to everyone who has attended part 2. Definitely, again, as said before, we will be sending out the recordings for 1 and 2. So if you are looking to receive that, just please type your email in the chat, and we'll make sure to get that out to you. But again, thank you so much. Thank you, Kate. Again, we received a lot of good feedback from those who've attended, very valuable information. So again, thank you for that, taking the time to do that. As well as for those of you here, again, we do have another upcoming Lunch and Learn for next month. I believe that topic is going to be on, correct me if I'm wrong, Michelle, it's on
Newcomer barriers.
Newcomer barriers, thank you. It'll be on newcomer barriers. So again, if that's something that interests you, or you think someone that you know might be interested in that, please forward that email or let them know. But again, we'll be reaching out again just to invite all of you back once again. So thank you so much. I hope everyone has a great rest of their day and a wonderful weekend. Thank you, everyone.